In Chapter 4, we're going to talk about the elements of a crime. The government, the people, the prosecution, whatever they're referred to, the state attorney, they must prove each element, as we discussed, beyond a reasonable doubt. With some rare exceptions that we'll talk about, every crime has at least these three elements. There is a criminal act, or an actus reus, as they call it, a criminal intent, or a mens rea, and a concurrence of those two things, the act and the intent happening at the same time. So my question is, do all crimes require a bad result? Consider driving while intoxicated. What's the crime? Driving while your ability is impaired, let's say by alcohol. So what's the act? Driving while your ability's impaired. You don't have to do anything else. You don't have to cause an accident. You don't have to hurt somebody else. That's all you have to do. And that's considered a conduct crime. Your conduct in and of itself is a crime. On the other side of that, we have a consequence crime, which is a crime that requires a bad result. Murder requires a bad result. The intent to kill somebody. What's the result? Somebody has to die. So there's a consequence. Let's go through some more examples here. Conviction for a conduct crime. Prosecution need only to show that defendant has engaged in the specified criminal behavior of that statute. Okay? So for a conduct crime, remember that the defendant engages in a specified criminal behavior with some level of fault. And we'll talk about that in a second. Intent is our mens rea, but there's some level of fault. But for example, breaking and entering merely requires proof that the defendant in fact broke into a structure and went inside, regardless of how long they're there, whether it's slightly or an hour or longer. Another example would be placing a prohibited pollutant or a contamination into a navigable water. All you have to do is put that pollutant in the water. That's the specified act, and that would be a crime if it says it's illegal to put a pollutant in the water. They don't have to prove that that pollutant hurt anybody. For breaking and entry, there's no proof that something else happened there. That's the crime. And a consequence crime or results crime, it's also called a result crime. The prosecutor must prove only that the defendant engaged, not only that the defendant engaged in the prohibited behavior, but that a specific harm was also done. So, like I said, homicide is the most common example. The prosecution would have to prove that the victim actually died and that the defendant caused that death. Another example, back to my pollutant. If you put a prohibited pollutant in a navigable water in the United States, and let's say the law continues on that says, and thereby causing death or seriously bodily injury. The prosecution has to show both those things, that the defendant put the contaminant into the water and that the contaminant actually caused the death or serious injury to the person. Some crimes, both conduct and result crimes, also require proof of criminal intent, and we'll get there. In a conduct crime, the prosecution must prove that the defendant intended to engage in that prohibited contact and that it wasn't just a mere accident. The defendant generally doesn't need to know, however, that their conduct was illegal. In a result crime, the defendant must be proven to have either intended that result, murder, intent to kill, or at least to have some high level of carelessness. That's just a little introduction into mens rea that we're going to talk about. But in order for me to explain or give some examples, you kind of have to understand a little bit about what we're doing with the intent level. So let's say, for example, let's look at this law that I put up here for criminal mischief. You have committed the crime of criminal mischief, we'll say in the 4th degree, if you do the following. You intentionally damage another person's property regardless of the amount of damage. So my question is this a conduct or a consequence crime? What has to happen? You have to damage somebody else's property. So this is a results crime or a consequence crime. Let's look at this example. So Brandon and Fred were at Fred's house. They got into a heated argument over politics. Fred ordered Brandon to leave. As he walked toward the door, Brandon nonchalant in a fashion pushed Fred's laptop computer off the table onto the floor. The screen cracked. Brandon, could he be prosecuted for criminal mischief in the 4th degree? Based on that example. He could be. Because his his act, what'd he do? He pushed the laptop. I didn't say he picked it up and threw it on the floor, but he pushed the laptop and it broke. So in this instance, this is a consequence crime. He caused the consequence. He acted. And we're going to be turning to Actus Reus in a moment. I just want to go through a couple of examples distinguishing conduct crime and results crime. Janie gets into a fight with her boyfriend, Conrad, after the prom. She grabs his keys out of his hand, jumps into his car, locks the doors. When Conrad strides over to the car, she starts the engine, puts the car in drive, and tries to run him down. It's dark and difficult for her to see, so Conrad easily gets out of her way and is not harmed. And the question is, can Janie be arrested for a crime? You might be thinking, well, she's tried to run him down. I guess it's going to depend on what crime we're talking about. So I'm going to give you 2 crimes. What if it is a crime to use a vehicle in a fashion to cause personal injury to another? Sounds like assault, doesn't it? Can she be charged with something like that? No, because we don't have Conrad being injured. Can we charge her with a crime that says you can be charged with reckless driving if you drive your vehicle in a manner that subjects others to potential injury? Totally making that one up. But if you intentionally drive your car in a fashion that can cause somebody else injury or another accident, that would be a conduct, because by your act of driving recklessly, and we'll talk about what recklessly means, then that's a conduct crime. So make sure you distinguish between the two. It's her doing the act. And I don't give you many details, but it sounds like, she's trying to drive over somebody, so she's probably not driving as a careful driver. Without any more details there. So let's jump into our elements. So make sure you keep in mind conduct crime, consequence crime, especially when we start talking about actual specific types of crimes. Criminal act, or actus reus. What is it? It is a unlawful bodily movement. That's the definition I believe they use in the book. It is illegal if you abduct another person. So what's the act? Taking another person. The statute, when you read the actual statute, whether it's homicide, whether it's driving while intoxicated, whether it's assault, it's going to tell you what the act is, what the forbidden act is. And the act must be done voluntarily. You break into your neighbor's house, steal the cookie jar full of cash or cookies, if you prefer the cookies. Your act of breaking in is you voluntarily doing the act. That is the act. But what if you're sleepwalking? Is that different? Is that voluntary? Nope, it's not. And the model penal code will not criminalize acts that are not bodily movements, not the product of the effort of the actor. And they actually list some examples. If you're hypnotized, you black out, you're manic, have convulsions, there's some other mental defect involved. So, does that make sense? You have to actually voluntarily act. What if you have a voluntary act followed by an involuntary act? Let's say, for example, the sleepwalking example. You sleepwalk into your neighbor's house, breaking and entering. You have to jimmy the lock. Somehow you do that in your sleep. And you get in, you're standing in the kitchen, you take the cookie jar full of cash, and poof, you wake up standing in their kitchen. And then you happen to look down, you see you're holding the cookie jar full of cash, and you say, okay, and you leave with it. Do we have a breaking and entering? Do we have a different kind of crime? How would you think this one through? Probably at the point you wake up and you leave with the cookie jar, you might be charged there with stealing something, theft, but would you be charged with the breaking and entering? Because you were sleepwalking when you did that. So these are the things you have to be on the lookout for when you are determining whether or not a crime has been committed. Was the act voluntary? Obviously, in the breaking and entering, it wasn't. You were sleepwalking, but once you woke up and you realized you were holding a cookie jar full of cash and you took it, now that's a crime in and of itself. Let's see, do I have another one here? What if you are claiming a status? And what I mean by status is I didn't mean to do that because I was drunk. I'm an alcoholic. What if I didn't mean to do that because I'm a drug addict and I was under the influence of drugs? Does that play a role in somebody defendant acting voluntarily? Most instances, that is not the case. That does not attack our act of whether or not the act was voluntary. It might have some basis for the level of intent, but the theory behind this is it's still a voluntary act because you can control your actions. It's not this is who the defendant is. It's not what the defendant does. It's like not out of your control. Addiction is a disease, but you can control your actions. Like you can control whether you're going to be drunk in public or whether you're going to use illegal drugs. So in the instance of doing an act that's not a voluntary act, being in those states is not going to help in the defendant's argument. So let's move to there are some examples in the book regarding drinking and driving and then passing out from driving. I'll let you guys look through them. I like some of the examples in the book, but we don't need to go through them all on the lectures, and this one's going to be a little longer than the ones in the past. So let me give you this example. So you received a failing grade on your midterm. You hate the grade that I gave you and the fact that class is let's say we had to report early in the morning, 8 a.m., but you can obviously look at this when you're available. But for my fact pattern, it's 8 o'clock in the morning. You write about this in your journal. You hate your failing grade. You hate the fact that it's 8 o'clock in the morning. You also write about the idea of rigging a bomb under my car so that when it starts, I'm going to be blown to bits. Your friend finds your journal and shows it to me, and I turn it over to the police. Did you commit a crime? Can you be arrested for something like attempted murder? No. Hopefully you're shaking your head no or saying no. No, you cannot. Why not? because you didn't do an act. You wrote about it, and you're free to write and think and do all of, those things. What you can't do is act on it. So there was no act here. Can a failure to act be a crime, meaning an omission? If you don't act, you could be arrested. Generally not, but there are a few cases where if you fail to act, you can face criminal charges. Most of the time it's reluctant to charge people because you don't want to put yourself in harm's way. And there is no Good Samaritan, save the day requirement under the law. But what there are, in some instances, a duty, that there will be an element of the charge saying there was this duty that this person owed, and that the duty existed and they didn't act on their duty, and hence we are going to charge someone. So when does a duty exist? Under 3 ways. The law says so. There's a law that says so. There's a contract that says so. And there's some sort of relationship. Okay, so this adds another element. So a duty will exist if the statute creates a duty, there's a contract creating a legal duty, or there's a special relationship between the parties. And this varies from state to state. If you are, like, for example, if you're an Olympic swimmer and you don't save a drowning child, that is not going to, the Olympic swimmer is not going to be charged. There's no duty. There's no duty there. Olympic swimmer may know how to swim and can do it, but doesn't have to. You watch your friend get beat up, you're not going to be charged for not stopping it. So the duty has to arise. Oops. Oh, I clicked to this example here, but there was one other thing that I wanted to mention relative to the slide that had the statute, contract, special relationship, and I can't click back while I'm recording. That's what happens when you're live, no editing. So just some examples where a duty arises under a statute. Filing taxes. The failure to file can be criminal. What's the omission? You fail to file. If you're a mandatory reporter for child abuse and you fail to report child abuse, you can be charged as well. Like I said, there's no Good Samaritan law that requires people to help. Under contract, doctor is required to help a patient. Lifeguard is required to help somebody drowning. A landlord has some duty to their tenant or their patron. If it's a like a store and you're visiting the store or using the store. Special relationship. This is not a stickler, but when the special relationship exists, I've seen this show up a lot. The duty is created. What types of special relationships do we have? Parent and child. If there is a parent, let's say a single parent who has a significant other, and that significant other abuses the child, and that parent is aware of it and doesn't do anything about it, that parent can be subject to charges as well as having the child removed from their care. A spouse to spouse has a special relationship. Employee and employer has a special relationship. Why do we have these special relationships? Especially if you think about it from the parent-child point of view. The child is dependent on the parent, needs the parent. So what if you put somebody in danger? What if you're the one who put the person in danger? What if you are horsing around with your friends on, some sort of ledge, people are jumping in the water below and swimming out and goofing around with your friends, and you shove one of them off and they go in the water, but they don't know how to swim, and then they end up drowning. Do you have a duty to rescue them? You do. If you put somebody in harm's way, you can be on the hook if you do not help. Parents, like I said, can be charged with criminal negligence of their children. People at nursing homes have a duty to care for their residents. Corrections officers have a duty to inmates. So, special relationships. And if you start, another point on Good Samaritans and starting before we jump into some examples here, if you start the act of rescuing, you have to finish it out, okay? So let's say I'm drowning in Lake Champlain and you are almost an Olympic swimmer. You're hoping to make the Summer Olympics, and you happen to be out for a run and you notice somebody drowning in the lake and you start to swim out to that person. Then you realize it's me and you realize, oh yeah, she gave me a failing grade, and you stop and you swim back in. You actually created the duty to have to rescue, so you have to follow it all the way through, or you can be criminally charged. Check out the book for further examples there, but let's go through a couple here. So Clara and Linda are shopping together. Clara stands by and watches as Linda shoplifts a bra, let's say, in the ladies' department at Target. Does Clara have a duty to report that? No, she does not. Jenny is standing on the shore of a public beach. There's a child drowning. Does Jenny have a duty to help? No, she doesn't, if she's just a patron. If she is the lifeguard, we just kind of answered this. If she's the lifeguard, yes, she does. What if she's in a Good Samaritan law states? There are some that impose Good Samaritan, but it's usually restricted to people in the healthcare business who can help and have the ability to help. Or if, it's a police officer who may be off duty, even though generally they do not have to. But some states have a Good Samaritan law. If we're in a Good Samaritan law state, Jenny would have to help if she doesn't put her own self in danger. If she doesn't know how to swim, then she certainly can't help, and then there's 2 people drowning. She's the child's mother. Yes, she has a duty. She's another patron on the beach. No, she does not. And the final one, what if Jenny is the one who threw the child in the water? Yes, she would have a duty to help. So that is our run through relative to Actus Reus and a voluntary act and omission to act. But there is one more area. We have this concept of possession. You can be charged with various crimes for possessing things you're not supposed to possess. Weapons, drugs. So if you're charged with possessing an act, criminal possession of illegal contraband in prisons, and that doesn't necessarily mean a weapon or a drug. You can be charged with possessing a weapon, and it could be as simple as a book of matches. But it's considered some sort of contraband in a prison setting. It certainly isn't here or at a camp outside of prison or in a campground or something. And we have 2 types of possession. You can actually have possession. It's on you or near you. Like when I say near you, like it's sitting on the desk right there and you're sitting right there. Or it can be constructive, which means it's in your control. It might not be in your pocket, and it might not be sitting there next to you while you're watching TV, but it might be in your bedroom, or it might be in your car, or it might be in your shed, these things that you have control over. And this gets really sticky because of the fact that there might be other people in your surrounding. So can more than one person be charged with possession of the same thing? Say, for instance, we are in a vehicle together, and in that vehicle, there's me, there's you, there's 2 other people. We're all friends, we're all hanging out. I'm not the driver. Let's say somebody else is driving. Me, you, we got another passenger in the back, and someone's driving. And we get pulled over. And let's say, as we're pulled over, let's say right in the red light. The driver gets pulled over, and the police officer comes over and says, do you know why I stopped you? Let me see your license and registration. And then at some point, the police officer goes, I think I smell marijuana in this vehicle, emanating out of this vehicle, and orders everybody out of the vehicle. To which they can look around, and they can certainly ask the driver, hey, driver, can we search your vehicle? Let's say the driver says, yeah, because the driver's just driving. The driver doesn't realize that all of us have kind of like, ooh, maybe we should hide our cocaine or this bag of pot over here, and any other, oh, wait, I shouldn't probably be carrying this handgun. We stick that under the seat. And so the driver lets the police officer search the vehicle, and they come up with all of this, or the police officer comes up with all of this stuff we hid around in the car. And the question is, who gets arrested? Everyone. Everyone in the vehicle gets arrested, including the driver. Even though the driver may had no idea whatsoever at that point, has no idea this has happened. Everyone can be charged with possession of those drugs and possession of those weapons, regardless of whose it was. And the prosecution will have to show constructive possession. Was it in your control? And the poor driver, it's his or her car, is going to be on the hot seat. But the key is possession has to be done knowingly. So a lot of arguments have been, we'll touch on this a lot further when we talk about these crimes, drug crimes. They're way at the end of the semester, but we'll revisit this actual constructive possession again, because it is really sticky. This scenario that I just gave you happens all the time. I've lost count of how many people I've represented who have been in this kind of scenario, who have been pulled over in a vehicle and everybody's charged with the drugs that are found or the weapon that is found. So this is common, but the prosecutor has the big job of proving that possession was done knowingly. And if it's not on the person, constructive or in their control, they have to show that. So without further ado, we're going to move on to the criminal intent, or the mens rea. That is a big area. There are a number of intent, or I should say states of mind, that one can be in and be charged. It's not just he or she intended to do this.